welcome to Arbitration Acumen, a podcast from Bracewell's International Arbitration Group that connects in-house counsel and arbitration practitioners with industry experts, institutional insiders, and top arbitrators from around the globe to share their views on key issues in arbitration today. You can reach out to any of today's speakers by emailing arbitrationacumen@bracewell.com. And we hope you enjoy this episode of Arbitration Acumen.
Welcome back to the next episode of Arbitration Acumen. In this episode, we're fortunate to have Claudia Salomon joining us, who's president of the ICC Court of Arbitration, to discuss recent developments at the ICC, including the annual statistics released on July 2nd and the new 2026 ICC rules. I'm JP Duffy. I'm an international arbitration partner based in New York that acts as both counsel and arbitrator in international arbitrations seated around the world under a variety of governing laws and arbitral rules. I'm qualified in New York, England and Wales, and the DIFC courts in Dubai, where I previously practiced. I also serve on the ICC USA Arbitration Leadership Committee. I'm a co-chair of the Life Sciences Task Force being sponsored by ICC USA, and was previously a U.S. delegate to the ICC Commission on Arbitration and ADR a few years ago now. As I mentioned, Claudia Salomon's with us today. She's currently the president of the ICC Court, which is a role she's been in since 2021 when she became the first female president of the ICC Court. In 2024, she was reappointed for a second 3-year term. And before joining the ICC Court, Claudia was the global co-chair of the International Arbitration Group at Latham & Watkins, based in New York. And before that, Claudia was the global co-chair of the International Arbitration Group at DLA Piper in New York, where she and I practiced together. I last spoke with Claudia on a podcast to discuss the 2021 ICC rule amendments. So we're keeping up a trend here with this episode that we're going to have to make more frequent, Claudia. And thank you for joining today.
Thank you so much for having me.
Good. Well, I won't waste time on giving background about the ICC. We usually do that with organizations, but I think anyone who doesn't know the ICC can just Google that one and they will find what they need to know. It's certainly a well-known organization that speaks for itself. So let's jump right in and talk about the 2025 annual statistics that were just released on July 2nd, because it appears to have been another banner year for the organization. So congratulations on that. What struck you most about those statistics?
Well, in terms of major milestones, last year we registered the 30,000th case, and that's certainly significant. And we did have a very strong year with over 880 cases filed under the arbitration rules. But really what struck me in terms of last year, and it's really what's signature about the ICC court, is the incredible international breadth. I mean, we had parties from 147 different jurisdictions. We had arbitrations seated in over 120 cities in more than 70 countries, and arbitrators from 93 countries. So that, to me, is a story worth telling and really notable, because sometimes we still hear, oh, if it's ICC arbitration, it needs to be in Paris, or ICC involving European parties, but it's really the global breadth is reflective in those statistics.
Yeah, that's really amazing. Now, what was a city that jumped out at you as surprising or unexpected for a seat, if you have one?
Well, I think what's most notable is that while there are certainly the major known arbitration hubs as the most prominent seats, Paris, London, New York, Geneva, Singapore, we have the cases seated literally everywhere. That's also reflective of parties using their bargaining power. I have done an analysis and have seen that more than 50% of our cases are actually seated in the same jurisdiction as one of the parties. And that was actually very surprising to me. So it really does mean that parties are using their bargaining power, but that when the counterparty says, okay, I can agree to the other party's, let's say, governing law and seat in their jurisdiction, where they will push back is to say, no, we have to have a neutral, independent, trusted institution. And that's where they then agree on ICC.
That's great to hear. And it's also good to see that people are starting to appreciate that having a seat outside of Paris is certainly possible and commonplace. I've got matters right now pending with a seat in Los Angeles. I've got one with a seat in the Midwest, which was surprising to me. So yeah, people are starting to appreciate the ability to see things outside of where the institution is housed, so to speak.
The last thing I just want to highlight about the statistics is really the fact that we had over 600 awards last year. Some of those are partial awards and some are final awards, 607 awards total. But 67 were returned to the tribunal for further consideration before the court approved the award. And that is really worth pausing on. That's about more than 10% of the awards. And I think that's indicative of the scrutiny process that the ICC court provides, what's really unique about ICC arbitration, and to really understand that had those cases not been under the ICC rules, those awards would have almost certainly been issued by the tribunals. And then the only avenue of recourse that a party would have is to go to court to get the award vacated. So that is really the quality control, that extra level of protection that parties get with ICC arbitration.
That's great to hear, because I think some people get confused by the scrutiny process and what its function is. And that really is the purpose it serves, to avoid issuing an award that's going to be subject to challenge for procedural reasons or whatever reasons, and, hopefully minimize the possibility that there's some error that will require that. So that's really useful. Just to take it back to something that you were speaking about before, obviously the ICC has a huge international breadth, but one thing that jumped out at me was the number of cases that involve parties of the same nationality in 2025 as well. And it looked like it was a little over 30% to me. Does that represent an effort by the ICC to capture more quote unquote domestic transactions, for lack of a better term, or what does that reflect to you?
Well, certainly since I started as president of the court, it's been something that I have focused on as an area of growth. We certainly see a lot of quote domestic arbitrations in Brazil, where we have an office in Sao Paulo, and that's administers cases involving all Brazilian parties. And what we see is the state entities are even using ICC arbitration in their domestic contracts. But we have seen really a variety of parties from so many different places opting for ICC arbitration, basically saying, we trust ICC for our international contracts. So why would we use a different institution when our counterparty is from our same country, when the ICC rules and our ICC arbitration works perfectly well in a domestic or international context? And I think one of the most notable aspects of that is the number one nationality for domestic arbitration under the ICC rules are U.S. parties. And so that is something where there are other arbitral institutions, but they are really trusting ICC in their domestic and international contracts. Lastly, to note, what appears to be domestic on paper, meaning all the parties are from the same country, often involve an international element. It could be that one of the parties is a special purpose vehicle or a local affiliate that's being used by the global or international company for contract purposes or for tax purposes or for other reasons.
Yeah, that's an excellent point. And that one I was going to raise myself. I think to your first point regarding U.S. parties, that you certainly do see that more, and in particular industries, I think with increasing frequency, where parties say, well, look, what we are looking for is a sophisticated tribunal, world-class rules, and incredible customer service on the administration front. So why don't we choose ICC? And then to your point as well, you do oftentimes see it is a foreign parent company or someone like that that's really driving things. So you might see two parties from the same jurisdiction on paper, but in reality, it is a foreign party or two parties from different jurisdictions in substance. So that's an interesting point.
And we've seen a change, for example, with international companies doing business in China with Chinese affiliates. So on paper, it's all Chinese parties, where in the past there was understanding that parties were required to use certain Chinese arbitral institutions, but various courts in China have recognized and enforced ICC arbitration awards where those cases have an international element, even though all the parties are Chinese entities.
Interesting. Okay. And that's a market that we could probably spend an entire podcast on because that is such an interesting market to me.
I know you spent time in Dubai. We see ICC cases involving all UAE parties, all Qatari parties, all Saudi parties, and that has been very interesting.
Yeah, again, that's a real reflection of how much confidence people have in the process and the rules and the institution, because those are jurisdictions that take those things very seriously. So again, a very positive development. And I'm sure it helps having a local presence in Abu Dhabi as well with getting people to understand the process, seeing a face of things, all very positive. One thing that jumped out at me as well out of the 2025 statistics were 36% of the new cases registered also fell below the $3 million threshold from the 2021 rules for automatic application of the expedited procedures. How does that number compare to previous years?
As in previous years, approximately 50% of cases actually involve an amount in dispute between $1 million and $30 million. And we see, I would say, about 40% below $5 million. And so it's not so much the shift, but also the growth in the number of cases under the expedited procedures, because those procedures don't apply unless the contract is after a certain date. So we see more and more cases under the expedited procedures as disputes arise under the contracts that have been entered into after that time.
Interesting. Okay, so we'll talk about this more, I think, as we get into the 2026 rules, but that threshold has also been increased going forward. Now, do you think the increased comfort with the expedited rules is increasing parties' willingness to submit smaller cases as well that they might have previously viewed as uneconomical? What I mean by that is I think there's been obviously a lot of acceptance of the expedited rules now that they've been in place for a while. And conversely, I had this issue recently where someone came to me with an arbitration that was relatively small. It was a big client, but they were saying, like, we've got this small matter. What do you think? And I said, look, I personally can't do this for you, but we do have the option to use the expedited rules, and someone more junior could handle that, and it would be an economical prospect for you. So do you think that increased experience with the expedited rules is leading to more people being willing to bring more smaller cases?
I do. Certainly, the large law firms are not handling the cases involving less than $1 million, but the reality is we have large percentage of cases with such small amounts. Last year, we had a case where the amount in dispute was $2,500. That's half the filing fee. So that party must have been really angry or really believed in their case. But the most important thing from our perspective is that they understood that they had an avenue of recourse. I mean, just this morning, I considered potential arbitrators for a case involving about $125,000. I think it's a combination of the expedited procedures where it really is an answer to parties' concerns about time and cost, and also the fact that our fees for arbitrators and the ICC administrative expenses are an ad valorem system, so based on the amount in dispute. So parties don't need to be concerned about runaway hourly expenses for arbitrators for a case that doesn't warrant that amount of expense.
Interesting. Yeah, I heard about the $2,500 case during the ICC USA Leadership Committee meeting, I think last week. And I have to say, we'll have to take that one up offline because I found that very fascinating. Somebody must have been very upset about that.
Yeah. And also for the expedited procedures, what's notable is that parties are opting into those expedited procedures. Last year, we had 11 such cases, but we see cases where parties have opted in where the amount in dispute is over 100 billion USD and even more. And really a message from the statistics from last year and also a real message under the new 2026 rules, which is as parties are thinking about their dispute resolution clause, it's really, really important for parties to consider, do they want expedited procedures or the new highly expedited procedures, which we can talk about, not to suggest that that's the right solution for every case, but it's definitely worth considering.
Well, and that's certainly part of the flexibility of arbitration as well, right? Like you might get into a case and all of a sudden realize this is really something, despite the dollar amount, that could be resolved quickly or needs to be resolved much more quickly than normal and might require less of the infrastructure to do it. So it would make sense. Are you seeing those types of opt-ins in any particular industries?
Well, I should emphasize that once a dispute begins, it's often difficult for parties to agree on an expedited process. It does sometimes happen, but more often than not, one party wants the process to go slowly while the other party wants it to drag out as long as possible. So most of the agreements between parties to opt into expedited procedures happens at the contract drafting stage rather than once a dispute arises. And I would say we see the opting in into a variety of industries and particularly in commercial disputes.
Got it. Now, I saw there were also 25 emergency arbitrator awards in 2025, with 15 applications being dismissed, 6 being fully granted, and 4 being partially granted. How does that compare to prior years?
I would say 2025 is generally consistent in terms of numbers over the last 5 years. We've had a range of 17 EA applications filed in 2024 up to 33 in 2022. So it's generally consistent.
Got it. Are you seeing any trends develop in the numbers as reasons for more applications being denied than granted? Like, do you see any common thread there?
Generally, dismissals remain the majority outcome each year, and 2025 is broadly consistent with prior years, although fully granted applications increased compared with the prior couple of years.
Interesting. I wonder if that's a function of people getting more sophisticated as to when they bring these things, or, do you see any reason behind that, or is it just the numbers are what the numbers are?
I think the reason that more applications are denied than granted is just the fact that emergency relief has a higher threshold. We, in essence, record the outcome as dismissed broadly, but where a reason is specified, the most common grounds are admissibility and lack of jurisdiction. And then more generally, applications appear to be denied when the emergency relief standards are not met. That could be because of urgency or a requirement that there's a need to show irreparable harm.
Interesting. Yeah, I've done a lot of emergency arbitration over the years, and one of the common threads I see is oftentimes a true lack of urgency, which is interesting given the type of application at issue. But when you dig in, a lot of times you do seem to find that to be a problematic aspect of cases. So something to keep in mind. Now, one of the things that I noticed as well out of the 2025 statistics was that 34% of all individuals confirmed or appointed by the court were under the age of 50. Does that correlate in any way to the number of small cases that you're seeing as well?
Often, but not always. I would say we really have an impressive number of arbitrators from around the world who are under the age of 50, also serving in complex cases. What is notable is the average age of arbitrators appointed or confirmed is 56. But the average age of arbitrators specifically appointed by the court is 6 years younger than the global average. So that makes sense because the court is more likely to be appointing the sole arbitrators in those smaller cases. And in those cases, oftentimes we could have an appropriate case, first-time arbitrator or somebody with less experience than would be required in a much bigger or complex case.
Great to hear. And that's just a plug on that. I mean, it is important to appoint younger arbitrators for appropriate matters because that's how you develop the next cadre of people. So very good to see.
And most people do get their first appointment from an arbitral institution. I certainly did. And it's just important for the ICC court to assess the right person for the job in the same way that parties and their counsel are thinking about who is the right person for this job. So if a case involves 100 million USD and involves multiple claims, we are not going to be appointing a first-time arbitrator. The parties would be shocked if we did that. We have to be appointing somebody who has the requisite experience to handle such a case. Similarly, a case could involve not that much in dispute, but still be extremely complicated. And oftentimes then we do look for somebody quite experienced, even though the monetary value is low.
All excellent points. And that's really the trick to being a good administrator, I guess, is understanding when it's appropriate for the right arbitrator. So good to hear. Now, one thing that jumped out at me as well was approximately 30% of all the arbitrators confirmed or appointed were also women, and 44% of ICC court appointments were women as well. How does that compare to prior years?
Well, we have just seen such incredible, significant change with regard to gender diversity over the last 10 years. Just to give an example, in 2015, only 7% of the arbitrators nominated by parties were women, now compared to 23%. 10 years ago, only 10% of the arbitrator, typically the president of the tribunal, nominated by the co-arbitrator was a woman. Now that's 30%. And the numbers that I'm most proud of is to see the big shift from 2015 with regard to the number of women appointed by the court. It was 20% 10 years ago, and now almost 45%.
Wow. I mean, just a market shift. And it's, I guess, not surprising, too, given that you are the first female ICC president. So good to know.
And it's really, though, a reflection, and I emphasize this point repeatedly, but it bears repetition, which is we will never appoint somebody because of diversity or because they are a woman. We are always focused on the best person for the case. What I think these numbers really reflect is the big shift in the number of women who have tremendous experience as arbitrators and are really recognized as world-class now.
No, I think that really does bear repetition because it is the right person for the case, and there is no reason at all to assume that the right person for the case would be of any particular ilk. It is choosing the right person. So it's great to see the recognition of the numbers going up because that is truly an important aspect of things. Now let's shift gears a bit and talk about the new 2026 rules, because that is a really big development and there's some really interesting facets of those. So the ICC introduced the new rules that came into effect on June 1, 2026. When did that process of revising the rules begin?
The process really began almost 2 years ago. We did a broad request for comment to the global membership of the ICC Commission on Arbitration and ADR, basically to say, if you've got any ideas or any thoughts whatsoever about how to improve ICC arbitration, let us know. And we actually extended that comment period. So both the former membership of the commission and then the current membership of the commission could provide that comment. Then the Bureau of the ICC Court, which is comprised of the 19 vice presidents plus myself, along with the senior leadership of the Secretariat, really worked as the drafting committee. We had a 2-day retreat. We met virtually multiple times to really dive into all of the policy questions. The leadership of the commission was also extremely valuable. And we submitted 2 drafts to the Commission on Arbitration and ADR membership and sought their comments. And I think that is something worth noting. This was not a behind closed door process. This was not a small group of people making decisions. This was really a global consultative process in which we really heard and considered the voices from around the world, and also, to emphasize, really heard the voices of in-house counsel. And some of the changes were specifically because they raised points that outside counsel and arbitrators had not.
Well, that is something, and I know that's been a focus of your presidency, is making sure that you're more responsive to users and that you're taking users being the ultimate end users, the actual companies using ICC arbitration and the actual parties participating. And some of the changes are clearly reflective of that. Let's talk about that a bit. What do you see as the most important features of the 2026 rules?
Well, perhaps the biggest change is just the elimination of the terms of reference as a mandatory step. And I highlight that as the biggest change because it's been a feature of ICC arbitration for over 100 years. So many people really thought, well, we should just keep it because it's a unique feature, where from my perspective, it really had outlived its utility. Another kind of major feature, and happy to talk through some of the elements, is the addition of the Highly Expedited Arbitration Procedure, which is an opt-in tool, but it's really part of our focus of giving parties a variety of tools to achieve their goals of resolving their dispute.
I definitely do want to talk about that because it's something that I think is really interesting. You're starting to see that pop up in various rules now. But before we talk about that, let's just talk about making the terms of reference optional. I personally think it's a wonderful development because for those parties that want the terms of reference, it's obviously still a possibility, but it's not a requirement anymore, which can be a long process in certain cases. So what prompted the decision to make the terms of reference optional, given that they were such a longstanding feature of prior rule iterations?
Well, as I mentioned, I really had the view that they had outlived their utility. It's interesting to kind of go back and understand why the terms of reference were in the rules in the first place. 100 years ago, some courts did not recognize as enforceable what we understand as an arbitration agreement. The standard arbitration agreement is in a contract before any dispute arises, stating the parties' agreement that if a dispute arises in the future, it will be decided by arbitration and specifically under the ICC rules. And at that time, that was something that some courts did not recognize as enforceable. So the terms of reference were necessary to actually identify the scope of jurisdiction of the tribunal. What exactly is the dispute between what parties that the tribunal should resolve? And that's quite interesting because that is in essence now defined by the arbitration agreement. So that's no longer necessary. We also see that the requirement that was previously in the rules that the parties identify the issues to be decided at the terms of reference stage was something that many parties and arbitrators found to be too early, and they weren't really able to dive in or weren't willing to dive into that process and were basically saying the issues to be decided are the issues to be decided in the case. And so what we really wanted to do was eliminate that requirement. We've seen in the expedited procedures where there's now over 1,000 cases that the terms of reference are not required. The sky did not fall. And when arbitrators and parties found the terms of reference to be a valuable case management tool, they went ahead and entered into the terms of reference.
The terms of reference really existed as a historical function, right? I mean, that's your point. They were there because they were a requirement in certain jurisdictions. But I think to your point, I just had this issue relatively recently where it was too soon to define what the issues were. So the issues were defined so broadly that it almost becomes meaningless. It can become a bit of an exercise in futility in certain cases. What's the expectation in your experience with the expedited procedures? What's the expectation for how many cases or what percentage of cases do you think will still deploy, I guess, the optional terms of reference, if you have a sense of that?
Under the expedited procedures, it's a handful of cases. So I don't really see the terms of reference being used that much. In Brazil, for example, there is a real culture of using and liking the terms of reference. So it may be that the Brazilian parties are more comfortable continuing to use it. Otherwise, if there's really a need to define, for example, jurisdiction or other issues, one option is to basically have agreed procedural order number 1. So there's a lot of different ways in which parties can think about how to, in essence, kick off the case. What's most important about the elimination of the terms of reference is the cutoff for new claims absent approval from the tribunal. So now the cutoff is the same as it is under the expedited procedures, which is the first case management conference. So for a practice pointer, parties and counsel really need to be thinking about their claims and defenses and articulating them leading up to the case management conference.
Which is great. I mean, that's relatively consistent with most major arbitral rules around the world. So I think most practitioners would be comfortable with that approach because they're used to it. It is an important development because I just had this issue recently where a party, they're representing a respondent in an ICC arbitration, and the claimant was rattling sabers about making new claims right before the hearing. It was an interesting exercise. So good to know that that's being considered. Now, one other thing that jumped out at me, there's obviously quite a few things, but one thing I wanted to discuss before we get to some other points was the addition of the express early determination prospect. And I know that's something as well. I've written on that. I know you and I have spoken about that topic that's been of interest to you as well for a while. What prompted that addition to the 2026 rules?
Really, it was feedback from in-house counsel in particular, especially from in-house counsel of global energy companies, where they felt that the fact that the early determination process was described in the note to parties and arbitrators was not sufficient to eliminate some ambiguity or fights about whether a tribunal would feel comfortable with that process. And so in my mind, it was consistent with one of our key goals, which was clarity, and in essence, articulating one of the inherent powers of the tribunal and not having any ambiguity around that.
It's great. It's a really welcome development because I think that is something that users around the world have always been cognizant of. And I share your view that, that's an industry where I've heard it, but many industry participants have told me, look, one of the features of arbitration that we're concerned about is the lack of an early off-ramp. And it's oftentimes an educational process to say, no, there is in fact an early off-ramp for claims that are deficient in some material respect that don't require a hearing on the merits. And sometimes having to explain under the prior rules that, look, the practice note allows this under the ICC rules could be a challenge. It's very good to know that that has been considered and added because it does add a lot of clarity. And I think it gives a lot of comfort to users. I mean, again, I know that was one of your focuses under your first term and certainly your second term as well.
And there was definitely concern that it would be weaponized and then potentially have the effect of lengthening arbitration proceedings if respondents regularly sought to have early determination when it wasn't warranted. And so one of the ways in which we've sought to protect against the abusive use of this tool is that a party needs to bring an application to proceed, and it is within the tribunal's discretion to decide whether there will be an early determination process. So if, for example, someone were to bring an application for early determination a few weeks before the final hearing, the tribunal may very well decide it's not efficient for the process to include that proceeding, and they would just go directly to the hearing.
Yeah, no, that gatekeeping function is really important because you do see, again, the ICC's breadth is so global and you see a variety of different practice styles around the world, but some counsel from some jurisdictions obviously reflexively try and bring dispositive motions when they're not going to serve their function, which is really to narrow the case and create procedural efficiencies. That gatekeeping function is important. Conversely, though, having it be expressly in the rules, I think, does signal for certain arbitrators that this is a process that should be used in appropriate cases, because you do also see that other extreme of, I think certain arbitrators being reluctant to allow a dispositive motion on the notion that it could create some sort of enforcement defense or procedural disadvantage for one of the parties, but there's really no reason in appropriate cases why you can't have early determination or a dispositive motion. It's such a valuable tool. So really good to see that this has been added. Now, one of the things I noticed as well was the addition of the possibility for ex parte emergency relief. Maybe you could just chat about that a bit.
Basically, the emergency arbitration process is designed as an additional tool in parties' toolbox to get preliminary injunctive relief before a tribunal is constituted. If a party feels comfortable going to the courts, then by all means, that is the way to go. One of the options that many courts around the world, not all, but many courts allow is for an ex parte proceeding. In circumstances where the communication of the application itself would undermine the relief sought. And from our perspective, if the emergency arbitration process is to be a true alternative to the courts, then we should provide the same possibilities that parties could get in courts. And it really is a situation where sometimes communication itself would undermine the relief sought. And so it's also reflecting practice where we have seen some ex parte applications requested.
Interesting. Well, that's a trend that certainly seems to be developing around the world as well, because I think this is now the third or maybe fourth possibly institution to add that feature. So it's an interesting one. I've not dealt with an ex parte application, but I'm sure it will come at some point soon. So it'll be an educational experience for me.
And again, it was very important for us to ensure that there were safeguards in the process. And so, to be clear, the emergency arbitrator can issue a preliminary order. And as soon as that is issued, then it is communicated to the responding party. And the responding party has to be given an opportunity to be heard. Then the emergency arbitrator can issue his or her final order connected to the EA process.
Interesting. No, it's very clear that there are procedural safeguards built in to ensure that every party is afforded fair treatment. So that is very clear. It is an interesting process. Now, in the interest of time, we could talk about the 2026 rules for quite a bit, but I would love to hear more about the topic you raised earlier, which is the highly expedited procedures. So maybe you could talk a bit about those, because I think those are a very interesting feature that is certainly one that I find intriguing. So why don't you tell us a bit about that?
Certainly. The Highly Expedited Arbitration Procedure, which now has the acronym of HEAP, is opt-in, and it provides for a final and binding award within 3 months from the case management conference. So unlike the expedited arbitration, which is 6 months, this is a final and binding award within 3 months. As I stated, it's opt-in only, so no parties can be forced to be in such a highly expedited process. Also, to emphasize that there's no monetary threshold in connection with highly expedited arbitration. So parties might choose to have highly expedited arbitration for some of their smaller valued contracts, but they might also decide that they just really value the certainty and the speed in cases involving rapidly changing technology, in a case involving a purchase price adjustment, in a case where it's clear that the dispute turns on a contractual analysis and not a lot of factual issues. And so time will tell what parties decide to do, but it's really not designed as other arbitral institutions have done, which is to say, okay, for small matters, we have fast, and then for medium-sized matters, we have medium speed, and then we have regular speed. It's really designed as a tool for parties, regardless of the amount in dispute, where they think speed is appropriate. I should also highlight and want to highlight that it took us actually a lot of time to draft these procedures. And I'm stating that not for the credit of it, but to say that in the early iterations, we found that things in the process just didn't work. And that is reflective of also my experience when I was counsel, and probably yours too, that when you see parties try to draft these procedures for themselves, they often wind up with pathological processes. And so this process has been really thought through. It's front-loaded. So it's really focused on ensuring that the parties make their submissions fully early on, but that it's not designed to basically cram in everything that would otherwise be in a regular arbitration in this short time. So while other institutions have adopted 3-month processes, they have not really articulated the steps around what the process would actually look like. And what we've sought to do is to say to parties, if you want speed, this is how it can be accomplished.
No, I think that's a really interesting point because one, you do see parties trying to craft these things on their own, and it can be incredibly problematic. And the outcome usually is some Frankenstein process that is not going to be effective. I think you also see a lot of industries where this will be incredibly valuable because they are trying to get some sort of speedy outcome for appropriate cases. And the thing that jumped out at me as well is I think this will be an interesting process for, you mentioned like a valuation situation. I think there could be a lot of potential for using this in instances where you might otherwise use an expert determination, because those are their own animal and they have their own shortcomings and their own advantages. But I see this as a possibility to not fully replace those things, but in some ways either supplement them or deploy them in a case where you might want more than just factual determinations. You might want something less than a full arbitration. So sort of some sort of hybrid situation where you could really address a key issue early on that has both legal aspects and factual aspects, but not a ton of factual aspects, which sounds very trite. But I mean, if you have, for instance, a royalty issue in a certain jurisdiction, well, yes, that might have some factual aspects, but they might be easy to decide. And they might also have some legal determinations that need to be thrown in that make it too challenging for an expert determination. So lots of possibilities there. And it'll be interesting to see how that plays out. With that, let me ask you a slightly different question, because the 2026 rules are really interesting and we could go on about them all day. But I think related to that would be, what would you like to see the ICC accomplish for the remainder of 2026? And I should presage this question by saying you'll be concluding your second term in the middle of 2027, absent some kind of expectation change. You've been incredibly successful in your first term. You've been incredibly successful in your second term, but you're getting towards the back end of your run. So what would you like to see the ICC accomplish for the remainder of 2026? And then I guess related to that, what would you like to accomplish for the remainder of your term as the ICC president?
So personally, over the next couple of months this summer, I hope to ride my bike as much as possible. I'm going to ride 5 days on the Erie Canal. And with that, I think I need to reread Moby Dick by Melville. But for the ICC over the remainder of the year, what we really want to ensure is smooth operations under the 2026 rules. Any case now filed after the 1st of June, unless the arbitration clause expressly is linked to, for example, the date of the contract, then all new cases are under the new rules. The ICC Commission on Arbitration and ADR will launch the report of the Corruption Task Force. We hope to also see approval of the AI Task Force, which has been focused on the use of AI by arbitrators. And in the fall, we'll begin a process to select my successor. But for the remainder of my term, which I have now just a little bit less than a year, I really hope that the institution is known as having what I would term a client mindset, that we're really focused on the needs of the parties. And well, maybe more specifically, my predecessor used the term glocal, that we were a real global institution with local connections. And we've announced that we'll open an office in Africa. We haven't yet announced the city. So that will be upcoming. And I would say stay tuned for further developments in which we really strengthen our glocal element.
Well, that's good to know. I won't comment on the legal aspects of things because I think you've got those well covered, but I will tell you, if you're going to ride down the Erie Canal, make sure you stop in Herkimer and get some Herkimer diamonds. They're a unique geological feature of New York State. So good fun. I took my daughter up to Herkimer from my undergrad university a couple of years ago, and we picked a few of those up. So good fun there. And I think you've deserved your ride and your time on your bike because you've been incredibly active over the last few years. And particularly the last two have been really quite a number of developments at the ICC. So with that, let me thank you, Claudia. This has been a real pleasure and informative as always. I think we'll wrap up our discussion of the ICC 2025 statistics and the 2026 rules. I want to thank our guest, Claudia Salomon of the ICC, for sharing her views and insights. And I want to thank you, the audience, for listening. You should feel free to reach out to Bracewell with any questions you might have today about the podcast, as well as to Claudia, who I know will get back to you. And we look forward to having you tune in for future episodes in our Arbitration Acumen series. Claudia, thank you so much. Such a pleasure as always. So informative. And as I say, you have absolutely earned time on your bike because it's been an incredible run.
Great. Thank you so much.
Great. Well, thank you.
Thank you for listening to this episode of Arbitration Acumen. We hope you found it insightful and informative, and we encourage you to share it with your colleagues if you did. You can reach out to any of our speakers by contacting them directly or by emailing arbitrationacumen@bracewell.com. We welcome any questions or suggestions you might have for future episodes. And please subscribe to our podcast channel to stay up to date with our latest content.